Welcome to another edition of Crime News with Mark Solomon. It is Monday, September 20, 2021, and today, not good news, yesterday, the FBI believes they have found remains consistent with Gabby Petito in Wyoming. We're going to be talking about that. There's a warrant being executed right now in Florida on Brian Laundrie's home, and they are still looking for him. And we had a great viewer question that we're going to talk about in depth. Stay tuned. Yesterday, the news was all awash of the FBI having found the remains of a human body, which is consistent with Gabby Petito. This is in the Bridger-Teton National Forest in Wyoming, where she was last known to be. The cause of death has not been determined, and there's an ongoing investigation. They're asking people not to show up there. That's really important. You'll get in the way of their investigation. And as that happened yesterday evening, right after my video yesterday talking about some of these issues with the case, this morning, the FBI is searching Brian Laundrie's home after getting a search warrant. They have a court-authorized search warrant related to the Petito case. The warrant comes after investigators still searching for Landry, who returned home to Florida without Petito earlier this month, declined to talk to investigators, and then went missing last week. But remember, he's not missing. He's in hiding. That was his statement through his attorney. And that's really important to remember. He hired an attorney to make a statement before he went into hiding. That was his goal. What they're saying is that, here, quote, "At this time, we currently believe we've exhausted all avenues in searching the grounds here. On Sunday, the human remains were found in Wyoming. Again, the posts of their trip abruptly stopped in late August. Landry returned to his home in Northport, Florida, but with their van, but without Petito on September 1. And Petito's family, unable to get in touch with her, finally reported her missing on September 11. Heartbreaking news. Let's go ahead and get to the question from our viewer here. I have a question. I know it's best to tell your attorney the truth so you can get the best defense. If you're charged with something and you tell your attorney you did it, is it covered by attorney-client privilege? And the answer to that is yes, it is. Attorney-client conversations are some of the most protected conversations in the United States. I can imagine national security and things that the president talks about is probably more so, but the attorney-client privilege is right up there. Let's take a look at the rule of professional conduct, which governs that. When you look at Rule 1.6, it's the confidentiality of information. This is all governed under the rules of professional conduct. Each state has their own rules, and they've adopted them slightly for each individual state. These are the model rules, and Rule 1.6 says a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent or the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. In that case, a lawyer may reveal information relating to the representation to the extent that the lawyer believes it's necessary to prevent reasonably certain death or substantial bodily harm. Think about the implications there. If I had a client who said, I'm going to go out and kill somebody, I could probably disclose enough information to keep that client from doing that, calling the police, warning the person. But again, only to the extent that the lawyer believes it's necessary to do that. In other words, that doesn't give the attorney carte blanche to go out and just spill his guts about everything. They have to be as restrictive as possible. The last one I'm going to talk about here is to secure legal advice about the compliance with these rules. So if an attorney doesn't know what to do, he can always talk to another attorney and disclose enough facts to be able to get a good opinion about what the attorney should do. So when we talk, and the rest of them are not very relevant here, what I will also talk about is there's another rule as duties to a prospective client. Now, A prospective client is an attorney-client relationship where the person is talking to an attorney about whether or not to hire the attorney. The attorney has not been hired in the case or the matter, and the attorney is still bound by the attorney-client privileges because here, a person who consults with a lawyer is a prospective client. Even when no lawyer-client relationship ensues, a lawyer who has learned information from a prospective client shall not use or reveal that information except as Rule 1.9 would permit as far as the respect to information of a former client, which is also extraordinarily restrictive. So the interesting TV shows where somebody's like, I'm thinking of the TV show Breaking Bad, where Saul Goodman says, give me $1, give me $1. That way that way you've hired me and it's confidential. You don't need to give the attorney money for information that you've given them to be confidential. If you think that it's an attorney-client relationship or a prospective attorney-client relationship, that conversation is protected. Let's move on to the next part. My question in a case like this, you're not charged, but you tell your attorney that you killed somebody. I mean, somebody just hires you and says, I murdered somebody and the police don't know it's happened. So now you know of an unreported murder. What do you do then? Really clear. There's nothing I can do other than counsel the prospective client if they have not hired me, or if they have hired the attorney, then the attorney has the duty to represent them in whatever context they've been hired to do that. So in other words, the attorney cannot divulge that information. Otherwise, they risk sanctions by the attorney regulation folks. That's how attorneys get suspended or disbarred, is by revealing information that they're not supposed to. So if a client comes into an attorney and says, I did it, help me, your job as an attorney is to help them. And so shifting this and applying it to the situation at hand, if Brian Laundrie hires an attorney and says, I killed somebody, or not, if he just hires and says, I think I'm going to be accused of killing somebody because she's missing. I left her in Wyoming and I'm here in Florida. I need help. I think they're going to accuse me of a murder, but I didn't do it. Either way, I go back to what I was saying in yesterday's video, where you can't give a statement without risking harming your case, future case, or the current case you're fighting. So in other words, if an attorney, if I was the attorney, what do I want my client to tell me? Honestly, in the beginning, I kind of don't want to know too much because I want to know what the state knows first. And when I say that, I mean, I want to read the police reports, the witness statements, the body camera recordings before I hear what my client has to say, because sometimes what my client has to say isn't too helpful. I mean, it doesn't hurt me, but at the same time, what they say doesn't have too much context until I know what we're facing, what the evidence is that looks bad. That's when the evidence that looks good actually means something. So the first step is truly, in my mind, in most cases, don't give a statement and simply release a statement that says we're not making any statements. We want to be helpful, but we'd like to see what the evidence finds before we start cooperating. Something to that nature. Going back to the rest of the question, we now know that she is dead. Well, we strongly suspect they think it's her. Knowing that, what would it take a new client to say to you for you to tell them to say nothing at all and just see what happens? I'm of the mind that Brian likely minimized what really happened to his parents and to his attorney. I'm curious about this case because it seems like almost like covering up a crime if it hasn't even been reported yet, and somehow seems different than an admission once the charges are filed. I appreciate your thought. It's a really good idea. Unfortunately, I think you're wrong. And here's why. Most of the time, I will not want to make a statement, as I said earlier. Most people do minimize what really happened when they give an account, but remember, what they say to their attorney is privileged. What they say to their family is not. So when I have conversations with criminal clients, it's important that they not have their family there when we get to that part of the conversation that I'm actually wanting to know what happened from them. Because if we need their family or friends or other witnesses to be able to testify, the prosecutor can always ask that person, have you heard the defendant make any statements about this case? And if so, what did they say? That's not hearsay. That's a statement by a party opponent and can be used against you. So in other words, if I'm talking with the son, the adult son, and the client's mother is in the room and I say, what happened? And he says, well, I killed her and I need your help. She could be called as a witness for the state, and the state could say, what did he say about the killing? And she would be forced under penalty of perjury to say, he said he killed her. Well, that's not good for him. So it's always a good idea from the attorney's point of view, never to have anybody in the room when you're actually getting facts from the defendant. There are clever ways we can talk about things, but that's truly the best way to do it. Is it covering up a crime if it hasn't even been reported yet? The answer to that is absolutely not. In fact, the only time you'd be potentially in the situation of covering up a crime, and this is the standard evidence/ethics question, is when a defendant or prospective client comes into your office with the murder weapon and puts it on your desk and says, what should I do with this? And it's a huge problem, because now there are very strong laws on the tampering with physical evidence or the destruction of evidence, and same thing with witness tampering. You can't restrict the other party's access to that physical evidence, and if you destroy it or counsel somebody to destroy it, you've just now broken the law. It's really important when talking to clients that an attorney not do that. Also, it's not covering up a crime by protecting your client's right to remain silent. It's a basic foundation in our constitutional law here in the United States, and most states have enacted their own right to remain silent, where an attorney cannot violate that, even to the point where if you're in trial, the judge is going to ask the defendant, not the attorney, sir, you have a right to remain silent. You also have a right to testify. What would you like to do today? And remember, if you choose to remain silent, that silence cannot be used against you in any way, shape, or form by the jury, and the jury is going to be told that. It's such a basic foundational right that that happens outside the presence of the jury, so that the judge can know that the defendant is making that decision in a knowing, voluntary, and intelligent way. And the defendant is the one who holds that right, not the lawyer. It's one of those absolute choices that the defendant gets to make. So by not making a statement, even though charges have not been filed, the attorney nor the defendant, or prospective defendant, shall we say, are covering up a crime. They're just not reporting it. I'm going to read this again. I'm curious about this because it seems almost like covering up a crime if it hasn't been reported yet. It somehow seems different than an admission once charges are filed. And it's not. It's the exact same situation before, during, and after charges are filed. Very good thoughts. And I really appreciate that. It was an extraordinarily good question. That's why I wanted to do so much time on it. Well, when we get more information on the search results, if we get more information on the identification of the remains thought to be Gabby Petito, we will definitely be coming back with that. And until then, thank you so much for watching. If you have any thoughts, questions, comments, anything at all, please put them in the comments below. We'll see you back here next time.